Good afternoon, everyone. Welcome to our CLE on how to probate a will. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. And for those of you that are not familiar with DVAP, as we call it for short, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary goal is to match low-income Dallas residents with private attorneys that will do their case pro bono from start to finish. One of the biggest types of cases that we get, and we're seeing more and more since the pandemic, are probate cases. And we are in dire need of attorneys to take on these cases. So today we have Melinda Hartnett to tell us how to probate a case when there's a will involved. Melinda is a partner at the Hartnett Law Firm. She does mainly probate litigation. She got her degree from Hamilton College in New York and actually taught math in high school for the winter athletics in Lake Placid before going on to law school. She got her JD from Fordham Law School in New York City. And she practiced in Syracuse, New York, before moving back to Dallas and joining the family firm. She has an active member of the Dallas Bar Association. She's participated in Bar None, and she is one of our very active DVAP mentor attorneys. So whenever I have questions in probate law, I'm always bugging Melinda, who will set me straight and tell me what I need to know. If you have questions throughout the presentation, put them in the Q&A, and if we have a time at the end, we will get to those questions. So without further ado, I will turn it over to Melinda to talk about how to probate a will.
Great. Thanks, Kristen. Yes, so my topic is how to probate a will, steps to help and pitfalls to avoid. I used to call it steps to help you successfully probate a will, I think, but I can't make any guarantees, just hopes that this will help with some of the problems you might run into. I will say DVAP wills can sometimes be challenging and introduce some nice problems I don't always see, but it's a great way to learn and to get in front of the judges and to get to know the probate bar, which is full of very, for the most part, nice and helpful lawyers who want to help. So today I'm going to cover your first look at the will, information you need to get to probate the will, look at a simple probate of a self-proved will, simple probate of a non-self-proved will, issues to look for, what to do after the will is probated, and some tips, which you'll hear along the way as well, but I'll reinforce at the end. So your first look at the will, when the client comes in or drops it off or however you see it, if they can email you a copy, that's a great way to go so you're not surprised at what you might see at first. Your hope is that your will does not look like a will that we were involved with. This will involved a $17 million community estate. It was a very well-known University of Texas quarterback. We got in after the will was probated, but then we're working to get it knocked out of probate because there were some problems with how it was probated. So this was the will, one side of the will. Again, $17 million and went with this kind of a will. And you can see at the top, it says not a will, and on the side it has extra notes and X's through it. And then the back also had a lot of this is not my will, but then had this is my will, and I leave everything to my wife. And one of the problems was we said you couldn't tell what was exactly probated when it was probated. And one thing is the judge did not know there was a child, not of the marriage. So we thought the one reason they probated it so easily was he thought everybody was on board, but in fact they weren't. So hopefully you won't have a will like that. DVAP will have gone through that and worked on any problems. So your first look at the will. I always look at the signature and the date. Again, you heard we do a lot of probate litigation, so I'm just inclined to look for any problems. How close to death was this? Does the signature look suspect? Does it look like a cursive signed signature? And look, sometimes you can tell it's somebody who's off the line or kind of looks pretty shaky, so you get an idea of, you know, what their condition was at the time. Were there witnesses, and is there a notary? While not exactly required, it's a much easier probate if you have 2 witnesses to the will. And the notary is actually for the self-proving affidavit. So you don't have to have that just for the will, but for a self-proved will you do. I look then at the specific and residuary bequests. Does it look like everything's above board? Do you see any problems? A lot of times these are simple wills, simple estates. So hopefully there's not a problem. It might be leaving a house to 1 child, you know, and then I'll ask questions about that. Is there an executor appointed, and are they appointed independent, or is there not some magic language in there that makes it independent? And then I'll look at the rest of the will, just to make sure there's no problems or anything that conflicts or just makes it a questionable document. I look at whether there's a self-proving affidavit. Again, not a problem to probate a will without a self-proving affidavit. It just involves some different steps and is a little bit more challenging. So I look at that. In a DVAP will, you've got a lot of people who have done a will on their own. It may even be holographic. So it may not have a self-proving affidavit. Then there's a question, is it original? And are you sure? It's getting harder and harder to tell if something is an original or a copy now with color copies and things like that. And some judges will give that a hard look and will let you know that what you thought was an original is not an original. Again, you can still probate it. It just involves some other hoops to jump through. This is what a self-proving affidavit in Texas should look like. It's not required, it's substantial compliance, but this is what you're looking for. This form, I think I got it from the probate manual. I'm not sure. It has testator and testatrix. We now call them just testator and also executor and not executrix. But this is what it should look like. You're looking for substantial compliance with the language here. It is signed by the testator. It's signed by the 2 witnesses, and the witnesses' signatures are notarized. So I'm going to show you, for those of you who've seen me or anybody else in my family speak, we do tend to share these videos because we think they're entertaining and interesting and give you an idea of problems you're trying to avoid and looking for red flags where you may have, you know, a will that's not valid. Just because it's witnessed doesn't mean you can trust it, doesn't mean it's valid. There are still questions. And in this case, the person who's speaking on the video and taking the video is a private investigator who'd been hired by this testator to get him out of a guardianship and succeeded, and then had him sign a will, leaving the bulk of the estate to him. Even though you'll hear on the video, he says that he's left it to a trust, but that was not true.
Okay, Buford, you just finished signing your will, right? Okay, and we have witnesses here as well. Cherie is here again to notarize it, right? And we have the 2 witnesses who are witnessing your signature, okay? And you're aware of what the will says and the fact that you're making bequests to several different people. There's a bequest, a large bequest to either a foundation or a trust fund or something that will then distribute money according to your wishes. You've left things to me and to Irene, and you've left things to about 5 or 6 other people specifically named in your will, right? Okay. Now, you signed the will. Were you coerced into making it? Did somebody beat you or force you to sign it? I noticed that you have in there a specific thing about your cousins. Okay, you've left them out. Why?
They didn't want me to have a country for this.
What do you mean?
Well, they told the judge that they agreed with everything you did. Took everything I had away from you for no reason that I could.
So you intentionally left them out of your will?
You bet.
Okay. You can add whatever you want to say. You're fine. That it? Okay. All right. Okay. Today is August the, what'd you say? 13th? 13th. Okay, 2015. Okay, thanks, Buford.
So in that case, the person speaking got around $5 million under the will. The trust that was created was not of any value whatsoever. And in the end, we had a successful will contest over in Tarrant County for Buford. So that's what we're trying to avoid. Again, just because you have a witness doesn't mean everything's good to go. All right, so you've got your will, you're ready to file an application. You need to gather some information. Obviously, you need the date of death. That should come into account when you're looking at the signature on the will and when it was signed and how close to death. Date of birth for the decedent. The decedent's residence, that'll help with venue. The applicant's residence. Social security number and driver's license number. The last three numbers of both the applicant and the decedent, if you can get it. If you can't, for the decedent, it's not the end of the world. Some of them, if they're elderly, may not have driver's license number, and you may not have access to the social security number. You need to go over the executor qualifications, and I'm going to go over that in the next slide. This is an important part about whether just because they're named an executor doesn't mean they can qualify. Also, does the executor live in Texas? If they're not in Texas, you need to have them sign a designation of resident agent, which can be the attorney or somebody else in the family. It's a good idea to know who the heirs at law are. Who would inherit if this will weren't probated? Are those people on board? You can just ask the person who's there. You may not trust that answer, but that's where you just get an idea of who's really going to contest and put up a fight. If nobody, then there's less concern. All right, the executor qualification. So there's no set standard for who's suitable executor and who's disqualified. We used to say, we've discussed the qualifications to be executor and you believe you're qualified and not disqualified to serve. Now the Dallas courts like you to go through these criteria here verbally with the executor or whomever is your witness who needs to know that about the executor. Need to be over 18 years of age, never declared of unsound mind, no felonies, no misdemeanors involving moral turpitude, no bankruptcies, no claims against the estate, and the estate has no claims against you. You want to ask those questions before you go to court and before you ask for this person to be appointed executor. But I will tell you, it's not unheard of to get in front of the judge and suddenly they say, oh, you know what? There was that bankruptcy 10 years ago. And sometimes they don't even say it like that. Sometimes they just say, yeah, I've declared bankruptcy. And you look like you never asked them the question. It happens. It's happened to all of us. The judges have seen it. A bankruptcy is not a deal breaker. You can sometimes still be appointed. It kind of depends on how long ago. If it's somebody in the 80s, they may still be able to be appointed. If it was in the last 10 years, there's probably going to be a problem with them being in charge of property. Some of the other things on there are bigger issues. If there's a felony, you're not going to get appointed. So you want to go over those if you can beforehand. All right. This is a simple probate of a self-proven will. And I call it simple because these days, nothing is really simple. They're all a little bit questionable, particularly in Dallas and maybe in all the big cities. You have one proof of death, and it can be an interested witness. It can be somebody who inherits. A lot of times it's children or a spouse, and they're a beneficiary under the will. So you need that one proof of death. You need an oath for the person who's going to be appointed executor. And you need an order probating the will. In court 2 in Dallas, there's some additional proofs that you may need. And sometimes they're adding ones or changing the language used. So it's a good idea to check their website. And we now have 3 associate judges. Each probate court in Dallas County has an associate judge. So if you're going to be in front of an associate judge, you need a waiver of de novo hearing for the associate judge. This is what a typical proof of death and other facts looks like in a probate case. And I just go straight down this. I highly, highly recommend doing that. You go forward and you can ask yes, no questions. So I'm going to give you an example. You say, you may call your first witness and they call Melinda Hartnett. And I would say, you were acquainted with John Smith, is that correct? And how were you acquainted? I was his daughter. And John Smith died on September 1st, 2019 in Dallas County, Texas at the age of 80 years. Is that correct? 4 years have not elapsed since decedent's death. Is that correct? Decedent was domiciled and had a fixed place of residence in this county at the time of death. Is that correct? So I would do that for each of these entries, each numbered line. I would ask that way and ask, is that correct at the end? So you get a straightforward yes, no answer. When you get down to number 6, the independent executor named in this will is not disqualified by law from accepting letters testamentary or from serving as such and is entitled to such letters. Is that correct? The answer, yes. Then you go through those qualification criteria. So, is whoever it is, Jane Smith, over the age of 18? Has she ever been declared of unsound mind? And go through those qualifications one by one. That is all you need to do. If it's an uncontested probate of a will, just go straight down the proof and ask yes, no questions. So then the witness will sign and the judge countersigns. Court 2 has these proof addendum qualifications. This is for the executor to sign, or is about the executor. Your witness may not be the executor, but they should be able to answer these questions. The other courts, as of now, at least 1 and 3, don't require this additional proof. And you can incorporate this into your original proof if your executor is the witness. Okay, this is another case. Again, just for a little fun and to shake it up, this is an old case where you'll see someone signing a will, and the person who the beneficiary is there helping her, and she's very tired. You'll see it's an old case, but old one, but a goodie.
I had a big bunch of stuff, and we decided that it would go into a residual trust after you make all these other gifts to like Henry Anderson, Texas Christian University, Scottish Rite University, University of Mississippi. Now it says in here, let me see if this is okay with you. It says fees and bonds, that there will be some fees for managing this estate. Is that okay? Okay, like the bank will charge, things like that. Okay. Now, it says here that on the 30th day, says Cleo Mason House. And you need to make an X right there, not up there, right here, right, put your pencil right behind it. And make it one of those big X's there. I'll make an X. That's Cleo, 3L, can you give me an L? E, O. Okay, that's pretty good. Want to try that Hamilton? Yeah. Try Hamilton. H, A, remember A, M, H-A-M, T, can you do an O-N on that now? O-N, okay, that's fine. That's good.
Hopefully you see that as a problem. Again, just because we have witnesses, just because they've signed it, doesn't mean you have a valid will. All kinds of things can go wrong. All right, here we have again, simple probate of a non-self-proven will. Not a problem, not required to be self-proved. It's just a bonus and makes the prove up easier after the fact, but no big deal without a self-proving affidavit. You can have a proof of death as above, and that can be an interested witness. But you also need a proof by a subscribing witness or another witness if the subscribing witnesses aren't available. You still need your oath, and you need your order probating the will. And you'd also have your de novo waiver if it's in front of an associate judge. This is what a proof by a subscribing witness looks like. And even though it's not numbered, I would still go through this the same way as I did before. And say, you were present and saw Mary Jack Edwards Ingle, the decedent, sign the document, which is now shown to you. Is that correct? Yes. And this purports to be decedent's will. Is that correct? Yes. And decedent published and declared to Charlotte Brewster and to you that this document was decedent's will, et cetera, et cetera. Yes, no questions, straightforward. And then here's a proof of decedent's handwriting and signature. If you don't have one of the witnesses there, someone else can prove up the signature on the document. Go through those numbered points one by one with yes, no questions, and you've proved up the will. So again, not a big deal if it's not self-proved. All right, issues to look for when you are looking at a will, probating a will. So a big issue is when it's not an original. Like I said, that's harder to tell now. You may file it and think it's an original and then have a judge call you up and say, got a problem. I've looked and I can tell you for sure it's not an original. They used to call it the spit test. You could wet your finger and it would smudge, but that's not even happening nowadays. It's just not that easy. When you have an original, you can still probate it. It is not fatal. It's just going to take more steps, especially depending on who the beneficiaries are. You have to plead some additional facts on revocation because there's the presumption that it's been revoked, and that's the reason there's not an original. So you need some information about where it could have gone or that you've looked for it and you couldn't find it. You also have to give notice to all heirs at law of the proceeding. So you don't have to, with a simple probate, you don't have to give notice to any of the beneficiaries. You can go file it and nobody will know. If you have a copy of a will, all of the heirs have to get notice because again, there's this presumption it's been revoked. So the court wants more eyes on this and to see if there's a problem. If the will leaves it to my children, John and Jack, you're probably not gonna have an issue. You're gonna have them sign a waiver or appear or do something to get notice. You can send it certified mail, but they have to have notice. In Dallas County, even if you have a self-proving affidavit attached to that copy, it is not considered self-proven. So you have to treat it as a non-self-proven will. In other counties, some of them consider it a self-proven will. I know Collin County does. I'm not sure about others, but you can find out from the court how they view a copy of a will. And in court too, there's going to be an ad litem appointed when you have a copy of a will probate. Another big problem is if your probate is beyond 4 years. You have to prove there's good cause for it to have been beyond 4 years. And I can tell you this varies greatly by court. There have been opinions on this and a lot of them conflict. So there's not a great answer for it. Of course, if the will looks suspicious, that's more reason for the court to have a problem with it. Sometimes it's the spouse didn't probate it, didn't need to, lived in the home, and so there was never a need. That person passes away, and then their child comes and says, well, now I need to probate dad's and mom's will. And courts have found that to be good cause, that it wasn't the child did not fail to probate the will. The child wasn't responsible for probating that original will. It was the spouse. So that's been found to be good cause. You have to make a pleading about why it is it wasn't probated. In court too, again, there's going to be an ad litem appointed if it's beyond 4 years. And with the probate of a will, you can't get an administration if you're probating it beyond 4 years. You're going to file it as a muniment of title, which I'm going to get to in just a second. So muniment of title, this is when you probate a will, you don't have an executor or administrator appointed. You're basically not going to have an administration. The will is probated and found to be valid, and it transfers title itself. There are plenty of lawyers who don't like muniments of title because, in part, later on they may find out, oh, we need an administrator, we need an executor to handle some problem, and you've got a muniment. You don't have it. It is already vested and passed to the heirs, however many heirs there are. I personally don't mind muniments under the right circumstances. You can't have any debts. So if there are debts and the people can't pay them off, then you're gonna have a problem with the muniment. If you can say, go deal with that debt, somehow get it paid, then you may be able to go with a muniment. If there are a lot of heirs, immuniment could be a problem. If there's a business, if there's something that really needs an active personal representative, immuniment's not the way to go. You want it to be a simple transfer of property. I ran into one problem once with Bank of America, I think, not wanting to divide up a large bank account among, I think it was 4 beneficiaries. We were able to push it through, but it involved me and involved their legal department. And so it was a little difficult. But again, with probate sometimes being a little more difficult these days, immuniment can be a way to avoid those problems. And it's going to come up in just a minute with some other issues you need to look for. So to do immuniment of title, especially in the DVAP cases, you need a MERP release. If you search MERP, M-E-R-P, on Google or whatever search engine, it will get you to the HHS web page, and you'll find the authorization and certification form. I'm going to have that in just a second, and you fill out part of that and send it to MERP, and they should send it back to you. It stands for Medicaid Estate Recovery Program. And it's basically if your decedent was on Medicaid after a certain date, then Medicaid may come back and try and get some assets from the estate. A lot of time in DVAP cases, they waive, and so you don't have a problem, but you need to have that form saying, we waive, we're not going to come after the estate. Otherwise, you can't get immuniment. Court 2 will have an ad litem appointed if it's beyond 4 years. So as I said, if it's after 4 years, you can't get an administration. You can only file it as immuniment of title. And as I said before, Court 2 would require it after 4 years anyway. So you know you're going to have an ad litem appointed. Court 2 also makes you sign an affidavit of no debts. So I said to do the immuniment, you need to have no debts or go have them taken care of. Rather than just testifying to that, Court 2 wants it in an affidavit. Here's what the MERP authorization and certification looks like. So you just fill out the top portion and section 1, and you can fax it to MERP. I think the information is at the bottom. Fax or mail the completed form to MERP, and then they should send it back to you. My niece has done a bunch of these and gets a response right away. Whenever I do it, it doesn't come back right away. I'm not sure, but we've called and gotten it taken care of a couple times. We've had to call, but it's generally not a difficult thing to get done. And as I said, they almost always waive. I don't know that we've ever had them not waive in our DVAP cases. And this is what the affidavit of no debts and no dissolution of marriage looks like in Court 2. They want this also signed, and you to go through with a proof. Again, it can go in your proof of death if it's a person who can testify to those facts. Okay, issues to look for. These I'm going to do kind of together. So do you have a disqualified executor? Maybe your executor has committed a felony or a misdemeanor involving moral turpitude or has a recent bankruptcy. You need to look and see if there's a successor named. If there's a successor who's qualified, then you're going back to those qualification questions. If there's not a successor, then you're looking at letters of administration with will annexed, which is when you have a valid will, but without an administrator appointed. Another problem is if you don't have the magic language for it to be an independent executor. And in Dallas County, at least, just calling it independent executor is not sufficient to necessarily mean independent. They're looking for specific language, says without bond and without further involvement of the court. Counties vary on what they consider sufficient language for independent. So then your question comes, will the heirs agree to an independent? Oh, I misspelled independent there, sorry. Will they sign a waiver and say, we agree that John may be the independent executor or independent administrator? If they will all sign that and they all have capacity to sign, the court will generally appoint someone independent administrator. If you have a minor involved, Dallas courts aren't going to grant you an independent. I would say never, but we'll go with almost never. It is pretty much fatal. You've got a minor beneficiary. They can't sign on their own and agree. And the court is so concerned about protecting those minors that they're not going to allow for an independent administration where there's no court involvement to make sure that the minor's property stays there. Also, if the will leaves the estate to my children, or worse, to my heirs at law, well, who can sign a waiver saying they agree to independent administration? You don't know. So the court is going to may require an heirship to say, okay, he had these 3 children. Those are the heirs. They've all waived. I'll appoint independent. At that point, you have a real question of whether it's worth it to go down this road. And I look again, is the muniment a possibility? Even lawyers who don't really like muniment under these circumstances may say, well, this is the best bet because a dependent administration gets expensive and onerous and takes a long time. It may not be worth it to go that route. So again, you're talking about wills that some people have done on their own. And don't know the magic language that's needed for an independent. So these can get a little messy. It's not hard. It doesn't mean it's not going to happen. It just means you have to jump through these hoops. And in the end, you may end up with a dependent administration. All right, if your will is not properly witnessed or notarized, that just has to do with the self-proving affidavit. Although not just with the affidavit, because if it's not properly witnessed, a notary can serve as a witness. So if you have your will that's, don't have 2 witnesses, and then you have the self-proving affidavit with your 1 witness and a notary, that notary can count as your second witness. Your will is just no longer self-proved. So that is a reason that having a notary, could help because it could count as your witness. But if you have a typewritten will and there's no witnesses on there, or there's only 1 witness and no notary, that's going to be fatal. You're not going to get your will witnessed. If a beneficiary is one of the witnesses, it can be fatal. It's not necessarily fatal because there are ways they can disclaim, or if it's not more than they would get under intestacy, it may work out that it can still be a valid will and they can be a beneficiary also. If the will is ambiguous, you may need or want a declaratory judgment to find out what the will means. This can be done early in the process, or it may be something that takes more time. Again, you're talking about who's going to complain, who's going to raise an issue with this, how big is the issue that you're talking about, how much property is it? But courts can deal with that and can construe a will. If you're going to have a lot of conflict over that, there's going to be another conversation, and DVAP would probably have known that already, because you're not supposed to be in litigation and handling that kind of matter on a DVAP case. Holographic wills. So we see this all the time. Texas allows holographic wills. Not all states do. It has to be entirely in the testator's writing. You don't need witnesses or a notary. You will need a proof of handwriting, which I showed you before. One of the proofs you could use. These are used a lot because it's no cost, and people think, well, I can just write it out. And no, I don't have a problem with handwritten wills, holographic wills. I've told friends if they don't have one going on a trip, it's not a bad idea to just do it, but then please go to a lawyer and have it done. Because problems come up with holographic wills. We've been involved in lots of will contests, lots of will constructions because they're not clear. And very rarely do they have the language needed for an independent administration, which is really what you want to get. So an example, and I believe this was a DVAP case for my niece. So a holographic will, and he does, a pretty good job. He starts it out, it sounds like a will. He adds in there, all my possessions to my daughter, Arrow, also executor of my estate, names the daughter, gives an address, seems to list some assets he has, and then goes back at some point, and as he sells them, maybe strikes them out, and signed. So valid will, no problem with this will. I suspect, I don't know what she ended up doing as administration. This would not be an independent, at least nowadays. This may have been quite a while ago. Would not be independent. Doesn't even say the word independent. Doesn't have the magic language to make it independent. not witnessed, so you're going to need somebody to prove up the handwriting. But otherwise, looks pretty good. I think she needed 2 witnesses and the court let her have 1 interested witness, although the practice or the rules says two disinterested witnesses. She got by with 1. Again, you know, DVAP cases, we're all trying to help. We're trying to get to the same place. I don't know if this is an only child that would help. You know, there can be circumstances that help you get through when you have a sticky situation or a difficult prove up. All right, so you've seen that just because the will is witnessed doesn't mean it's valid. I'll tell you, just because the lawyer's involved doesn't mean it's valid and doesn't mean the person wasn't influenced. We're going to have two videos here of this woman who is signing a will with a lawyer, and her son, who becomes a primary beneficiary under the will, is also in the room, and you can figure out for yourself if you think he is influencing her at all.
That says that you give $25,000 to Kathy.
Well, I can.
Is that what you want to do?
I can, if you got that down there. I give her money on this every month right now when I get my checks. But I will.
Okay, so you wanted to give her, and you said before that you wanted to give her $25,000.
All right, if you put it down, I'll do it.
Okay. You also said, now, do you want to give her anything else? Is that all you want to give her, is $25,000?
If I've got anything else to give her, I'll give it to her.
Okay. Also, Renee Guthrie.
Okay, part 2.
She's not married.
Now,
He's just his youngest brother.
okay, now if Michael were to die before you, who would you want? Would you want it to go to his children or to go to Lee?
I wanted to go to Lee, wouldn't I?
I would say my children.
Well,
Well, would you not want his children to receive it? When we talked before, you suggested to me that you wanted his children to receive.
you want me to say yes or no?
Well, kind of your decision totally.
Uh-huh.
It's your decision totally.
If he would die before me,
Right.
I don't think that's gonna happen, so I'm not worrying about that.
The way we have it written here is that in the event that Michael dies before you, it will go to his children. Is that okay with you?
It's all right.
So hopefully you're thinking, if you were that attorney, you would have seen these red flags and done something, stopped the signing at that point, and maybe done a little more research on whether this woman wanted to be signing a will and who she wanted her beneficiaries to be. After the will is probated, you have a few more steps to take. There are 308 notices. It's a state's code 308. You send notices to all the beneficiaries in the will by certified mail. You can get waivers, which is recommended. You likely all have experience with certified mail, return receipt requested, and getting the green cards back can be a challenge. So if everybody's getting along and you can, waivers are the way to go. Otherwise, send it certified mail. It's not necessary an immuniment of title because the executor does this. And as you know, you don't have an executor or administrator and immuniment of title. After you've done your 308 notices, you sign an affidavit saying that you gave notice or why you didn't give notice to certain people. There are a few exceptions. I think if they receive less than $2,000 and have already received it or things like that. So you have to sign your 308 affidavit with the green cards, or you've filed your waivers and you tell the court that everybody has signed a waiver. And the lawyer can do the 308 affidavit. Then you have an inventory, appraisement, and list of claims. You can also do, well, first I'll just say an inventory INA lists the date of death value of any property in the estate. If there's real property, we just use the appraisal district valuation, the tax valuation for that year. If it's bank accounts, you list where the bank is, the account number, but X out. Most of the numbers just include the last 3 or 4. So the bank name, address, and the account number, what kind of account it is, and the value on date of death. Personal property, you know, furnishings and personal effects, we go with garage sale value. Unless you're talking about something truly valuable, like specific jewelry or artwork, or guns, or something that has a specific value and may even need to be appraised. Otherwise, honestly, most people's houses are not worth what's in their contents is not worth a lot. What would it sell for in a garage sale? And just put that value on there. Alternatively, you can do an affidavit in lieu of inventory and appraisement. So some people don't want to put an estate value out there for the public record. You're still supposed to prepare an inventory and give it to all the beneficiaries. And then you file an affidavit that says, I've prepared it, I've given it to them, and we're not going to file the inventory. It's a standard form and that can get filed. You want to make sure that you have, you know, cross your T's, dotted your I's on that and figured out, again, who's going to complain. If everybody's on the same page and in agreement and they're already communicating, this may work fine. And, you know, it may be a kind of informal inventory that they give to their siblings or whomever. If you've got people who are going to fight about it, you want to do it like it's a court inventory that you're going to file, and then you can decide whether you file it or not. Oh, and the list of claims is not claims against the estate. You actually don't even list that on the inventory. You don't, if you have a house that's worth $400,000, you don't then have to list, oh, but there's a mortgage of $200,000. The list of claims is claims the estate has against other people. So if there's a personal injury action or money owed or something like that, it goes in the list of claims. And if you file the will as a muniment of title, afterwards you file a report of compliance saying, I've taken care of whatever I needed to do in the estate. You don't have an executor, so it's the applicant who signs this. If all there is real property in, say, Dallas County, where you probated as muniment, you don't have to do anything further. That any title company will look in the probate records. If they have real property in another county, you need to file your order probating the will as muniment in that county, in the deed records. Once you've done that, you can sign your report of compliance. All right, some tips that I have. First of all, I highly recommend getting the probate manual, Dallas County Probate Manual. It's put out by the Probate Trust and Estate section of the Dallas Bar Association. And if you search online for Dallas County Probate Manual, it will come up. You'll get the link to be able to purchase that. It has loads of forms for probate administrations, heirships, guardianship. I think there's powers of attorney. There are lots of forms that you can use. I now start with those forms. If I'm going to be doing any kind of application, rather than grabbing an old form that I did, you know, even if it was last month, I just go to the probate manual because I know the judges have approved it. So I'm probably good to go. You do still want to check court websites, especially Court 2, to make sure there's not additional language that's needed. But if you go with the probate manual, you're pretty much safe. I'll have lawyers send me a judgment in an heirship or order probating, and it's, you know, I just read it and I think, why didn't you just start with the probate manual? Because it's much simpler and laid out. And we all know what it looks like. So I highly recommend that. It also has an appendix. Well, it has an appendix with lots of things, but it has the Dallas County, I think Tarrant, Collin, and Denton County, like tips. What do those courts think? So for example, non-self-proven will, or copy of a will, is it self-proven? And that's where you'll see Dallas County says no. Collin County said yes, it can be self-proven. You can see what each of the 4 courts, how they handle that. How do they handle attorney ad litem fees? Do you need affidavits for things like that? So highly recommend getting the probate manual. The last version is 2020, but I think they're going to have an update soon. Use the court staff. I say this carefully because they're not going to give you advice. But if you've got a difficult situation, maybe service is a problem, or you're not sure about the copy of a will, call them and see if they can give you any guidance to how that court handles things, or what kind of affidavits, what additional affidavits are used. All 3 courts now have a staff attorney, so they have someone you can talk to there as well for a resource. So I recommend reaching out to them, in moderation, but they can be very helpful. The state code sections that you're going to be looking at are 256 to 258 and 301 to 310. Always a good idea to check there, especially with your more difficult cases. If there's something like you've got a witness problem or the beneficiary is a witness, go to the statutes and see, because there are some exceptions for things like that. Remember to use the proof for your questioning. I don't know if it's just lawyers, we like to talk, so we think you need to, elaborate and make it a lot harder than it is. Or you're thinking, well, yes, no questions aren't allowed. I can't lead the witness. If it's an uncontested probate, you can lead the witness, go straight down the proof. That's what the judges want. They want you to go straight down so they can follow and make sure you're hitting all the points. They may have their own questions at some point, but if you can do that, that's the best way to go. I'll tell you, my very first prove up years and years and years ago, my brother, who I practiced with, had told me, oh no, you just need one copy, go down to the courthouse with one copy. And so immediately the judge said, Miss Hartnett, can I have your proof? Which was my one copy. So I handed her the copy, and then I was just asking questions left and right, trying to remember everything on the proof. It got probated, but she called me up afterwards and said, next time, please just go in order of the proof. And it was embarrassing to tell her that I only brought one copy, but that's what I did. So I learned my lesson there. One second. If you have any intestacy, so this is probating a will, so hopefully you don't run into that issue, but sometimes you have that where it's heirs at law, or a beneficiary has died and it lapses. Always use a chart. No matter how long you've been practicing, it's hard to remember, especially once you get to separate personal property, separate real property, you've got children outside the marriage. If a potential client calls me and we get into intestacy or situation like that, I pull out one of my charts to make sure I'm not saying the wrong thing, because it will happen. It will happen, especially, some goes up to parents and goes down. It gets very complicated. Also, I've looked often online and found guides and checklists to probate, to what to do for a probate application or what to do for administration. So, afterwards, once the will is probated, and you can tell your client, here's what you need to do after, go to the bank, what you need to take with you. You need to have your death certificate. You need to have the letters testamentary or letters of administration, and what you need to have. So it can be very helpful. No reason to reinvent the wheel when you can get it right there. Virtual hearings don't seem to be going away entirely. Some of our courts are in person now, but some are keeping virtual hearings, which I think is convenient for lawyers. It can save some money. And also when you have witnesses around the country or around the world, it can be very helpful to have people able to testify, especially in some cases when you don't have simple witnesses nearby. But every court has their own requirements. You probably all know that. You need to look at how they want to deal with the proofs, how they want to deal with witnesses signing. Some courts want it signed ahead of time and e-filed, and some will have you sign on camera in front of the judge. Sorry, my throat seems to be a little bit dry now. Finally, know your court, be prepared, and prepare your client. As you can probably tell from what I've been saying, all the courts are different all around the state of Texas. They're a little bit different in how they go about some of this and some of the rules. So you need to familiarize yourself with their rules as much as you can ahead of time. Also, I now, for the last few years, have prepared my client that it may not go as we plan. It may not happen the first time, or we may have a setting and we may not even have a hearing at all. Prepare them so they're not surprised and you're not embarrassed if it doesn't go through. As long as you do that, I think, the clients are more forgiving than if you said, piece of cake, we can get this done. It'll be probated in a month and we're good to go. Don't set them up for that. Okay, so this final video, I believe it's the final one, is mainly audio. So some witnesses were there. The second wife or third wife had some witnesses come in and it was in a hospital, and the witness, it was I think a former student of the testator, and he was videotaping because he wanted, he thought he might not see him again and he was sick, and he started asking questions, and he happened to put the video camera down and didn't turn it off. I don't know if it's intentional or not, but he was actually a witness who was asking questions and saying, I don't know that everything's above board. And so we get some of the audio from him asking questions, and then the witnesses leave, and we hear the wife talking to him, reminding him why he's signing this will. She then got other witnesses later to be the witness, not the one you'll hear in the video.
Yes, it's his wish. Are we going to be doing it?
That's all right. This is not right.
You see, there's much you don't know about what's happening. And that's what maybe said it's none of your business. It's personal, what has happened, what those girls have done in the past. It has, we are doing exactly what we want to do. And you have no idea what has gone on. And I had no idea that this would come up, that you would call it right. And it says that you and I take everything and trust. And the advantage of the trust is, the advantage of the trust is business. See, if there's any money left, Michael gets it. Now, what they don't know is that this is your wish, but you told them the wrong thing. You told them that the girls are in this will, and the girls aren't. Because you told me you didn't want the girls in here, because the girls had been and mistreated you, and you gave them so much when they were alive. Remember that? Okay. The manager comes back and tell him that these, you tell me that we say anything, that these are your wishes because that's the way you want it, because you have given this girl so much when they were alive. Will you do that? Okay. You see, but Michael and Susan get it, and your girls don't get it. Now that's what this bitch man is complaining about, because he said the girls have been left out. You see? And it's what you want, isn't it? That's what you said. You're not going to back out on this, are you?
No.
And remember, Shannon gave me a heart attack. And remember how cruel they've been. She got to ship the children's wife and told them all these lies. And all that awful stuff that you don't remember.
So in the end, the hope is, you don't have a will like that. The DVAP cases have been vetted ahead of time and should be good to go, but you got to take a look at it. You don't want to put your reputation on the line for something that's questionable. Generally, there's not an issue. It's just jumping through the hoops. They can be a little technically challenging, but DVAP prepares you, gives you forms, and is there to support you, as are the mentor attorneys, to provide any help you may need, because it's just jumping through hoops. Not difficult, shouldn't be confrontational. It's just trying to get it done. So that is the end of the PowerPoint. I'm going to try to stop sharing and see about some questions that were here. I'm hoping that looks good. Okay, I stopped sharing. So I'm going to look at these questions. Can foreclosure proceedings be initiated during the pendency of a probate case? I don't know about initiated, and I guess it might depend in some on who the owner of the property is. I have certainly dealt with foreclosure issues while I was probating an estate or dealing with an heirship, and they could go forward. At least they told me they could. They generally didn't. If they found that somebody was going to be working with them. In fact, I have one right now, and it's a DVAP case where we are, if they know the probate process is starting and we're moving in the right direction, then they're going to hold off on moving forward on the foreclosure. So I haven't had an issue with that unless I wanted it foreclosed. Sometimes I did. Oops. Do we need all heirs at law if the will has a no contest clause? No contest clause shouldn't have any bearing on it. Most of the wills have them. Whether they're valid or not, it kind of depends. But no, it shouldn't have any bearing at all on probating the will and moving forward with that. Do you need a MERP release and muniment of title proceeding commenced within 4 years? You always need a MERP release and a muniment of title proceeding. Opinion on will forms preliminarily approved by Texas Supreme Court. You know, I looked at those only briefly. And I can't remember everything I thought. I mean, I don't recommend forms in general. I think that they, you run into a lot of problems. I think some of the DVAP cases you'll look at will have those problems because they've gotten them from, was it Zoom legal Zoom, something like that. And, you know, and now they're not necessarily specific for Texas, whereas hopefully the Supreme Court has done forms that, you know, are valid in Texas, but they still can be unclear. I think that the forms are supposed to be pretty straightforward. You know, if you're leaving it to all your kids, when I saw it, I think there were, you know, if you answer this way, then fill out this section and that kind of thing. I just think that people make mistakes and you'll run into problems and they may think that they're solid, that they've done it correct and there's nothing that could go wrong, and they still will go wrong. Okay, how would you move forward probating a will that is an unsigned copy, but is a conformed copy that shows the date it was signed and who the witnesses were, but there are no actual signatures on the document? Please assume all beneficiaries agree to probate the conformed but unsigned copy of a will. You have to know somebody, you're going to have somebody who knows that will was signed. You're not going to be able to just say, oh, we think it was signed and that's good enough and everybody agrees it was signed. You may need somebody who has seen the signed version or can testify about the signature. Otherwise, it'd be a very simple way for people to come up with their own will and say, oh yeah, it was signed. So the lawyer may be able to testify about the practice was to, you know, always have this kind of conformed copy and then give the original to the testator. But you're going to need something more than just the document and saying we assume it was signed. All heirs at law, also great. Well, I mean, that helps, but I still think a court is not going to just probate it as is unless you have some testimony that it was actually signed. After an inventory appraisement is filed with the court, does the executor have any more reporting requirements to the court? And when you don't have a muniment of title, so because you have an executor, it wasn't a muniment of title. Let's see, you do the 308 notices and you file your affidavit for that. You do your inventory. You have to do notice to creditors. I didn't have that on the slide. You do notice to creditors, and then the creditors have 120 days to file a claim. So they have to file a claim within 120 days, and you can give notice to specific creditors also. So unsecured creditors, you can give notice and then they're supposed to file a claim. But when it's an independent, if we're talking an independent executor, the claims process is not as stringent as in dependent. So it's a little harder to just knock out those unsecured claims in an independent. If it's a dependent administration, they have 120 days to file a claim. And then if they don't, and they got notice, then they're out. They can't file their claim. Well, if they don't file it at all, they're out. If they file a claim, it's rejected. They have 90 days to sue on it. That's getting into a lot of claims detail. But basically, so, you know, your executors want to be careful with distributing property within 120 days of the notice to creditors, because if a creditor comes back and there's no property there, there could be some problem. Kind of depends. Hopefully they know at that point whether there are any claims, and they are prepared and know, okay, no, we feel pretty good. We've been getting mail, or we've been involved with dad's estate for a long time. We know there's no creditors. Those are the only requirements I can think of off the top of my head for an executor. I think that's, once you've done that, they just have to, you know, administer the estate. Can creditors with unsecured debt force the sale of a home in the estate if the decedent's assets don't exceed the debts? It depends on whether somebody has a homestead right in the house or in the real property. So if there's a spouse or there's minor children or adults who are dependent, not just dependent because they don't do anything with themselves, but dependent, you know, they're never going to be able to be independent, then no, they have a homestead right in the house, and no one can do anything against that. And they have a right to have exempt assets also. Okay, another question popped up. Okay, this one is pretty, this one's getting pretty complicated. It's 1 o'clock. So I'm going to say whoever this person is, if you can email me, that would be great. And I didn't put my email on the slide. I think DVAP is going to send out my PowerPoint and I'll add my email. But if you want it, it's Melinda, MELINDA at Hartnett Law Firm is one word, HARTNETT lawfirm.com. Happy to answer any questions you may have. And I hope you learned something from my presentation today. Thanks so much.